All right. Good afternoon, my fellow commissioners. Good afternoon to our 151 participants. Glad to have everyone back. It is 2:01 and we'll get started back up with the closing statements for the mission change rulemaking. I believe we have 9 parties to go. We will start, I believe, Ms. Larson, with La Plata County, San Miguel County, Pickens County. Mr. Iachitis, I think I saw, is in the house. Good afternoon. You have, I think, 3 minutes.
Good afternoon. Thank you very much. And on behalf of La Plata County and San Miguel County, I would like to thank the commissioners and the staff for all of their hard work and careful consideration of all the issues that have been raised over many weeks here. We know you have heard our concerns and that we're very grateful for that. In particular, we're very thankful that you've adopted our requests on the coal bed methane wells in Rule 614. Thank you. That's very important to La Plata County. We also thank you for adopting our concerns about treating one residence the same as 10 or more residences in the Rule 604 setbacks. Along those lines, we note that in the definition of high occupancy building unit, it is conditioned to apply to a nursing home, for example, that serves 50 or more residents. And we would encourage you to take a look at that and apply the same principle of treating one resident the same as many. And perhaps you can address that by just including these residential facilities within the definition of a residential building unit so that they too will have the same setback, whatever it is that you decide. With respect to additional issues, there are 2 that I'd like to comment on. The first one is the tax certificate idea that we have floated to you. And we ask you to take that into consideration because if an operator doesn't have the financial ability to pay its taxes, it probably doesn't have the ability to comply with the rules and to undertake new activities. So we would encourage you to require a certificate that it has paid its taxes when it submits an application, and that an approval would not happen unless it's current with its obligation to pay taxes. And then finally, one of our issues is applying as many of the new rules to existing facilities as possible to promote the new mission. And of great importance to us is Rule 615 in requiring the new groundwater baseline sampling and monitoring requirements to existing facilities. We believe that it won't require new equipment, it doesn't require relocation, and groundwater is a scarce resource, and it's very important, and we think you should apply these new requirements to existing facilities. We also have a short list of other rules that we would ask you to apply to existing facilities, and we've identified those rules in our closing statement. And with that, I just want to thank you again for all the hard work that everybody has done on this. We really appreciate it. Thank you.
Thank you. I was going to actually acknowledge La Plata and San Miguel's thank yous that were in their closing statement. Nice to receive those every now and then. And all the tributes go to staff for the great work that they've done on that. Do commissioners have questions at this point in time? All right, thank you, Mr. Iachitis. Great to have you with us. We've appreciated the participation of your client group in this. Look forward to seeing you guys in our next series. With that, we will move to mapping for environmental justice, I believe. You're muted. You want to?
I didn't hear myself get introduced. Hi, commissioners. Thank you for taking the time to hear from everyone. I want to start by really thanking the Commission for considering the impacts of oil and gas on Colorado's most vulnerable populations. As we and other parties have demonstrated in our testimony, colorblind policies, like the ones that CRGCC has operated under in the past, lead to racial disparities, including in the oil and gas industry. These disparate impacts are exactly the reason additional safeguards are necessary. Your steps to identify DI communities and address these disparities are a good start, and we appreciate you and your staff's responsiveness to our suggestions on the definition. But this is going to fall short without significant changes. Alternative location analysis, for example, is one of the strongest potential protections that's proposed in the rules, and it should never be waived in the communities that need it most. We ask that you add this restriction to Rule 304B2B so that ALA cannot be waived within 2,000 feet of a DI community. On top of that, there are no restrictions on the proposed alternative locations. To be a protective standard, all proposed alternative locations should be located more than a half mile from the residents of DI communities. Language appropriate communication, as the rules are written, is only required for residents within 2,000 feet. This means that residents will only be informed if the minimum protective standard of 2,000 feet is being violated. We ask that these notification requirements and public meetings be expanded to include all DI community residents within a mile of the proposed location, so that the people who will be directly impacted can know about it, act to protect themselves, and participate in the process. Finally, the proposed setback exemption in Rule 604B1 for sites that have unanimous informed consent from nearby residents creates a situation that is really ripe for abuse and intimidation, and I really want to encourage you to be cautious in the development of this rule. To make this an equitable process with truly informed consent, the Commission needs to ensure that communities can engage on equal footing with developers. This could include an ombudsperson or legal representation, but significant guardrails are needed to ensure that consent is truly informed and respectful of the fact that not all Coloradans have the resources to negotiate for their health and safety against a group of well-funded developers. That's all. Thank you for your time. If you have any questions, I'm happy to answer.
Thank you. Do commissioners have questions for this panel? All right. Thank you very much. Appreciate your participation and the points you bring to the table. We now will move to Ms. Erin Martinez.
Can you hear me?
Yes, we can hear you, Ms. Martinez.
Okay, thank you. My name is Erin Martinez, and by this time, most of you know I am a survivor of the Firestone home explosion. I am here today to make sure that my story does not get lost during the rulemaking sessions. The lives of Mark Martinez and Joey Irwin were taken tragically that day, and it is very important that we honor their memories by pushing for change. I can't change my own tragic story, but I am hopeful that the changes we continue to make will keep this from happening to another family. Negligence led to my horrific nightmare, but proximity played a role too. The only way to keep leaks from being catastrophic is to move them away from our homes and schools. This can only be accomplished through setbacks. The well behind my house was 178 feet from my property line, and the flow line was 6 feet from my back door. My story is one of the clearest examples in Colorado history of the dangers of gas development overlapping with residential areas. Had my home been further from the well and the improperly abandoned flow line, gas would have not collected in my basement and Mark and Joey would still be with us. That's why I support the Commission requiring a 2,000-foot setback of oil and gas development from homes that prioritizes the health and safety of Coloradans. I strongly believe this setback needs to be a set value without any variation. Oil and gas is going to continue to flourish in Colorado, and so is development. The two will continue to overlap. The best way to ensure safety of our communities is to keep as much distance as possible between the two. I think it makes complete common sense to set the setback at 2,000 feet for residential homes. In the event that mistakes are made or problems arise, the distance between the two would save lives and keep tragedy from striking another family. And while I know that the current draft rules will not address the setback requirement for oil and gas flow lines, I hope that you as the commission and the staff of the COGCC consider in the future creating such an additional setback. I urge you to consider adding infrastructure to the proposed setback rules in Mark and Joey's honor. Oil and gas is not going anywhere in Colorado, specifically Weld County, where I live. The safest way to allow communities and the industry to coexist is proximity. Please consider increasing the setback and adding infrastructure, specifically flow lines. I want to thank the COGCC and the staff, as well as the other stakeholders, for their thoughtful work towards crafting a future for the Colorado oil and gas industry that creates more balance between the economic health of the industry and the health and safety of the people that live in proximity to gas development. I look forward to continuing to work together to make safety our top priority and to continue to honor the lives of my husband and brother. Thank you.
Thank you, Ms. Martinez, for those thoughtful comments. I think the commission want to thank you for your continued advocacy on these important issues and your tireless efforts. They are very well noted, and we appreciate that. Do commissioners have questions? Seeing none, thank you again for your participating with us in this proceeding and in all of our proceedings. We really appreciate it.
Thank you.
Ms. Larson, are we now at public water suppliers?
We are, and Ms. Brownhill's presenting on behalf of that party. I don't see her in the list of panel or list of attendees. I see a raised hand. Well, maybe. Let's see. If Ms. Brownhill could raise her hand. Looks like we have Ms. Teresa Johnson who's raised her hand. Ms. Brownhill, by chance, are you Teresa Johnson?
Yes, this is Stacy Brownhill. I think I might be signed in to Teresa's account. My apologies.
Not a problem. Thank you.
Ms. Johnson, we see that you've joined the panel and you have unmuted and we can see you.
Yes, good morning, and my apologies. My name is Stacy Brownhill. I think I'm logged into a coworker's Zoom account by accident.
Well, hello, Ms. Brownhill.
In any event, I'm here today on behalf of the public water suppliers. We're a group, as you know, of 12 parties that provide drinking water in the Front Range and rely primarily on groundwater supply. And I'm here today to start by acknowledging and thanking COGC staff for all of your hard work. We want to say a big thank you for all the changes in the 300 series and 400 series, and in particular Rule 411. And so my goal today is just to share in particular the changes that we support in the current draft rules. In the 300 series, we support Rule 303E, requiring operators to provide notice of a complete application to public water suppliers that operate a surface water intake 15 stream miles or less downstream, or public water supply wells within half a mile of the proposed working pad surface. So we support that notice. We also support Rule 309G, requiring operators to engage in a formal consultation process with those public water suppliers. And we support Rule 304B2B, requiring an alternative location analysis if the proposed oil and gas location is within a surface water supply area or within half a mile of a public water system supply well. In the 400 series, in Rule 411, we support the protections in Rule 411B for groundwater under the direct influence of surface water, or GUDI wells, and for type 3 wells, including the 1,000-foot setback. We're glad to see there's equal protection for Goody and Type 3 wells. We support providing an opportunity for a public water supplier to identify any missing ephemeral streams in Rule 411A1C, and requiring consultation on ephemeral streams in Rule 411A3. And finally, we support the added language regarding consultation for recharge facilities in Rule 411B4. So I want to say thank you again to staff for all of your hard work. We think these are great changes. We hope to see them in the final rules. And that concludes my presentation for the public water suppliers.
Great, thank you. Do commissioners have questions? Commissioner McGowan.
Thank you, Mr. Chair. Thanks for being here today, and I'm glad that the groups were able to get together and come up with some ideas. I think that some of the parties in their final comments are also supporting that the commission honor when a public water system accepts a waiver for within the buffer zone, and I'm wondering if you all support that language. I'm not sure I'm saying this the right way, but I think that's the gist of what some of the parties would like us to support.
I think in the current draft rules, I think we support the current language as is with those waivers.
Thank you.
Other questions? Great. Thank you, Ms. Brownhill. Seeing no further questions, we appreciate your presentation on behalf of public water suppliers and are happy to see where that draft is at this point. We will allow you to unpanel and bring in Mr. Jason Moore and perhaps others on behalf of Small Operators Society. Good afternoon, Mr. Moore.
Good afternoon, Chairman Robbins. I'm going to attempt to share my screen. And I'm afraid, let's see. Can you see my screen now?
We can see your screen. It's kind of small.
Yeah, I'll blow it up here in just a little bit. I'm not going to get to the slides right away. I just wanted to have them handy if I can get to them. So good afternoon, commissioners. I'm Jason Moore, counsel for the Small Operators Society. 3 minutes is not enough time to address the numerous rule revisions recently proposed by staff, so I will instead focus on some of the procedural concerns with this rulemaking that SOS believes jeopardize the quality and legality of these rules. The parties have only recently seen the significant revisions to staff's proposed rules and have not had a meaningful opportunity to comment. Many of these 11th hour revisions incorporate recommendations from other parties that are unsupported by the administrative record. However, the Colorado APA demands that all regulations be supported by substantial evidence in the record. A make it up as you go approach just doesn't work. The proposed revisions to impose setbacks in Rule 604 are particularly concerning. The Commission has proposed an entirely new setback regime that significantly departs from the current rules, staff's prior proposals, and the various parties' proposals. And yet this regime will receive no meaningful input from the parties prior to a Commission decision. By doing this at the 11th hour, this Commission has also failed to conduct an independent evaluation of how a 2,000-foot setback, let alone in conjunction with the setbacks proposed in the 1200 series, will impact oil and gas development in Colorado and the communities that rely heavily on the industry for essential services, employment, and affordable energy, all at a time when even our governor must be furloughed due to massive budget shortfalls. The Commission's 11th hour changes are an outlier compared with how other agencies conduct rulemaking. Whether it's EPA or AQCC, these agencies respond to other parties' proposals as part of the rulemaking process and administrative record. Here, we have heard little from COGCC staff regarding many of these proposed revisions, some of which depart significantly from staff's previous proposals. We have not even seen a revised SBAB justifying the recent revisions you are now considering. This commission simply has not established an administrative record addressing, much less supporting, a rationale for and consequences of a 2,000-foot setback. That you are even considering such a proposal in the face of the most perilous economic downturn this state has faced in a generation is nothing short of reckless. I'd like to now pause my time and ask for a time check to see if I have time to go through some of these slides that I have up.
Mr. Moore, you've
Ms.
used
Larson?
in 29 seconds.
I have 29 seconds. Okay. Thank you, Ms. Larson. I'm going to quickly show you, we had one operator do a very quick evaluation of what a 2,000-foot setback in conjunction with the proposed setbacks in the 1200 series would look like. So in front of you, you have a planned development on the west slope. You can see some small black squares that are building units, and you can see proposed gray squares, I think, sorry, it's hard to read, that are locations approved by BLM after a NEPA process. So I'm just going to scroll through. Here's adding in the 2,000-foot setback. And again, we keep saying 2,000, but in reality, it's a 23 or 2,400 setback. So these circles would be bigger, but they already start to encroach on some already approved locations. And now I'm going to start building in some of the 1,200-foot setbacks. Each time you see red added to it, that is acreage that would be off limits to development. So as I scroll through, when you look at all the setbacks that we're talking about, it would pretty much preclude development in this area. And that's why I think it's vital that this commission evaluate the impact that the setbacks would have in the 604, but also in conjunction with the 1200 series. And with that, I have one more slide, but I imagine I'm out of time.
Yep. You are indeed out of time, Mr. Moore. Before we turn to commissioner questions, and I've got great respect for you as an attorney, but I do take high regard to the way that you have castigated our deliberations and the work that we have done. The staff draft of 918 is not a surprise to you or to anybody else who has been participating in this several month long, if not 8 month long endeavor. The staff draft that came out on the 18th was to be expected because it was a reflection of the information and the debate from this commission to our staff after we had heard from all of the parties. And staff actually did what we asked them to do, which was come back with a staff draft that was informed by our direction. So for you and your client to call that reckless, I take great concern with that. So I don't have a question for you. I don't know if any of the other commissioners do, but I do want you to realize that I believe that your approach here is indeed reckless. Are there any questions for Mr. Moore? Seeing none, we'll move to the next panel. That is TPP Rocky Mountain LLC. Mr. Jewell, I see that you are with us. We'll let you unmute and audio and video yourself. Yes, we can see you. Hello.
Good afternoon, commissioners. Again, Michael Jewell on behalf of Terra Energy Partners and its wholly owned subsidiary TEP Rocky Mountain LLC. Given the large task that the commission is undertaking, things are going to change in the state. One thing that will not change is Terra's commitment to provide for the clean energy needs of our country in a way that mitigates the adverse effects of oil and gas development in Colorado. But to continue this leadership and success, clarity and certainty demand sharpening. So to that end, 3 quick points. I want to reiterate the need to reassess the MOU and how we're going to operate on federal lands. Number 2, make one last case that we reopen Rule 223 to protect confidential information. And lastly, most importantly, I will tell you how swans and setbacks are related. Stay tuned. First, TEP's heavy leasehold means 58% of its current wells and supermajority of its plans will implicate federal lands and most of the time even be operated upon federal lands. You compare this to the greater Wattenberg area where maybe less than 1% and almost always due to what's called Act 30 land. So we're really talking about different ownership here, and that MOU is going to tell how the COGCC and the BLM and sometimes the National Forest Service work together to achieve the best way to be efficient in how we operate. We're talking about concurrent or sequential permitting, and these questions can be answered through this process. I thank Kinder Morgan for suggesting some rule changes there, but I think the heart and spirit we're getting after is the same thing, that we can streamline some of the expertise that we have between the two agencies and be better for that. So please, by the end of Q1 2021, let's sit down with the director of the COGCC, the right people at BLM, Terra, and other stakeholders and get that done. Secondly, the rules centered around protection are on the forefront, and TEP, like other operators, want to know that not only their chemical disclosures, but also their engineering and methods can be protected. Right now, under the current draft, the director is kind of the stopgap, and as we discussed lastly, and Commissioner Gonzalez brought up, it becomes final agency action at the director. We fear that's going to cause an unnecessary trend toward litigation and holding things up, but we don't think that's proper. That's not in the interest of COGCC. This is something that's been done in other industries to understand and to collaborate on confidential information and handle that better. Lastly, back to swans and setbacks. You've heard several reports from PhD toxicologists. I want to stipulate they're all erudite, they're all valid. They all use a similar method for analyzing and conveying information. Unfortunately, you've heard from several, mostly lawyers, who are not trained in public health science, reduce this for you in a way that is not valid. That is, that observational studies equate to a narrative of science. They simply do not. They offer nothing more than observations that mandate further extrapolation and separation from confounders, like emission versus time versus distance versus population density. So I have to credit the undisputed king of the science and philosophy in the 20th century, Karl Popper, who suggested a scientific observation is like saying all swans are white. Then you say there's a black swan, therefore you are incorrect. Well, the same thing is at play with an observational study. An observational study merely says there are white swans, and the white swans here can be potential health detriments, but there is also black swans, mitigating factors and circumstances that go against that white swan. So each study just shows you a different mix of those proportions. These are called confounders. Without actual deductive study, like case control study, we simply cannot conclude anything about how these confounders interact with each other. So this matters for two reasons. One, the Chevron deference and other standards mandate that we rely on deductive and good science. If not, we're merely relying on psychological expedience. And that lack of appreciation of the proper science leads to unnecessary agency and legal disruption. Secondly, these confounders matter.
Joel, your time is up. If you could wrap up, please.
And one last sentence, because our mix of swans and the peons is different than the greater Wattenberg. Thank you very much for your time.
Thank you, Mr. Jewell. Are there questions for Mr. Jewell? All right, seeing none. Ms. Larson, can you let us know the order of the next panel?
Yes, if we could move to Weld County and Mr. Barker. We will be hearing from Weld Air and Water, but their presenter just needed a minute or two extra. So if it's possible to move to Mr. Barker first, then we would proceed with Weld Air and Water after that.
Good morning, Mr. Barker.
Good afternoon.
Or good afternoon, you're right. It's been a long day.
That's all right. Bruce Barker, Weld County Attorney, as set forth in our written response, with a few minor exceptions, Weld County supports the September 18th Series 200 to 600 draft series draft rules. Please adopt Rule 604B4 as drafted. That rule and its concept of substantially equivalent works well with Weld County's 1041 WOGLA process. We believe the draft rules strike a good balance between the permitting of oil and gas development and protection of health, safety, welfare of the environment, and wildlife. Also, they strike a good balance between the work of local governments and that of the commission. Weld County looks forward to amending our current IGA with the commission to better define process, procedure, and protocols, and thereby allow for good coordination and cooperation between our two government agencies. Thank you for your hard work the past 5 weeks and for allowing Weld County to be a part of this rulemaking process. Thank you.
Thank you, Mr. Barker. Are there questions for Mr. Barker or Weld County? Great. Thank you for participating with us this afternoon, Mr. Barker. We will allow you to be unimpaneled. And Ms. Larson, are we going to go back to Weld, Air, and Water now?
Yes, I've been looking for Ms. Matsumoto. I don't believe she has joined yet. Ms. Matsumoto, if you are in the meeting and could raise your hand, we'll make sure to call on you. I know she had a commitment that ended at 2:25, so she still may be running a minute or two behind. Mr. Chair, I'm not seeing her raise her hand, which that is the last participant or the last party who will be making a statement today. I don't know if you wanted, oh, I see a hand. Oh, excuse me, Mr. Teropoulos, thank you. We do have Mr. Teropoulos as well, I apologize, from Wildlife and Biological Resources who will be presenting. So Mr. Chair, we can move to him.
Great.
Let me try and share my screen and get the video going. Can you hear me okay?
We can hear you and we can see you, Mr. Teropoulos. Thank you.
Great, thank you. So I can see the PowerPoint on my screen. Is it coming up on, is it coming up for you?
No, we do not see the PowerPoint.
All right, let me try one more time. And if not, I can just wing it. Hang on. There we go. Is that working?
Yes, we can see your slides now.
How about that? Let's go. So Mike Teropoulos, Counsel for the Wildlife and Biological Resources Coalition. And first, a genuine heartfelt thanks from all of our members to the commission and staff for their hard work and dedication to get mission change right. WBRC has proposed all along that mission change will be a paradigm shift by definition. The legislative sponsors called it a sea change. Governor Polis, landmark oil and gas legislation, and we've emphasized that protections are paramount under the new law. I'll touch on 3 issues in my closing statement, and the common theme is informed decisions based on facts and science and proven regulatory approaches and strategies. So informed decisions, this goes into 3 of the series. The concept is public notice and comment for post-drilling operations that can significantly impact resources that we and other stakeholders care about. And we propose that in 3 sections. I'll touch on briefly. The alternative that we submitted, maybe a 2-pronged approach in our written statement, would be for stakeholders to submit information on habitat and other resources to be added to the case or location file, possibly a policy synced with the CIDR repository. So that might make sense to get us from A to B. Rule 211, plugging and abandonment, is one area where we want to see this public notice and comment. Second one is the Rule 308 Form 2s, covering the applications to drill, deepen, reopen or recomplete wells. And the third one is everything else, the form for sundry notices. The next issue is the Rule 300 planning. Cumulative impacts analysis under cider, very much aligned with Mr. Randall's testimony for the hunters and anglers on including qualitative evaluations of these resources that are mentioned. And as Coloradans, if we want to protect ecosystems and the environment, I would hope we all agree that this is necessary and this is the way to get from A to B. On the 400 series, nuisances, we want to add noise under table 423.2 to the categories resources entitled to the highest protective standards as supported by our witness testimony. And I think I got the last one here, and we actually have a prop. I thought I was going to be the last one. So it's Christmas in September when the Nuggets are in the NBA Western Conference Finals. The prognostication was that a small forward from Syracuse would lead Denver to the finals. And last thing I just want to recap what we're asking for is that the mission change rules provide for informed decisions protective of 181 values based on facts and science, proven and evolving regulatory strategies. So here's to the comeback kids and resilient ecosystems for Colorado kids. Thank you.
Thank you, Mr. Taropoulos. Appreciate that. Do commissioners have questions? All right. Seeing none, we thank you for your participation and your perspective. We will unimpanel you. And Ms. Larson, did you find the weld, air, and water, Ms.?
Yes, unfortunately, Ms. Matsumoto, she's still not in the meeting. I don't have any update from her other than I know she had a commitment until 2:25 today.
Okay. What I would suggest, and I know we just started, can we take about a 15-minute break, guys? I wanted to tee up the rules, the September 18th red line rules on my computer so I can share a screen so that when we go into deliberation, I can be able to get to the right spot. And I haven't been able to do that because I've been sharing this meeting. So if we could break until, let's see, if we could break till 3 o'clock, that would be 20 minutes. And then I could have my screen set up, and then we would then move into deliberation from 3 until 5. We probably wouldn't need to take another break, and we can see how far we get. Okay with everybody? All right, great. 20 minutes. Good morning, commissioners. Good afternoon, commissioners. It's going to be perpetually morning for me today. I don't know what's going on. And hello to our 176 participants. It's 3 p.m. Commissioners have today received closing statements from parties. And I think we are now at that place where we will move into deliberations on the 2 through 600 series. AAG Davenport, do you have any words of guidance for us? I've got some ideas that I'm going to introduce substantively, but are there any procedural things we need to be aware of? We've not closed the record, nor do I think it's appropriate to close it yet. I think we just need to do some talking amongst ourselves now, right?
Yes, Mr. Chair, that's correct. That's what deliberations are in effect in regard to closing the record. Closing the record essentially means the commission is decided it does not need any more substantive information from either the parties or the staff. And so I do not recommend that the commission close the record until it is certain that it does not need any more substantive information. And quite frankly, effectively, that means that I don't recommend you close the record until you think you're ready to vote.
Okay.
And
And,
Chair, I apologize.
oh, yes, Ms. Larson.
Yes, thank you. We do have Ms. Matsumoto in the meeting, so if we would like to take Weld Aaron
Oh.
Walker's closing statement, we can certainly proceed with that, and then.
Yeah, no, that would be great. I forgot that we were, part of the reason for the break was to give her a chance to get done with her previous engagement. So why don't we bring her into the panel and we will hear from her. Hello, Ms. Matsumoto. We can see you. There you are. And you need to unmute.
Hello, Chair Robbins and commissioners and staff. Thank you very much for the schedule accommodation. I don't know if Ms. Larson mentioned, but I was teaching the future generation of lawyers about the importance of careful discovery requests and really appreciate your accommodation. I'll be brief with my closing statements, and again, thank you all very, very much for the time and close attention you've invested in this process. I think that the rules have substantially improved, and I just want to offer 2 suggestions for specifically how disproportionately impacted communities could be better protected under the rules. If I could share my screen, let's see. Ms. Larson, do I have screen sharing ability?
You do.
Okay. Just make sure here. For some reason, I think I had this problem before. It is not coming up, but I will just draw your attention to 2 suggestions that the Weld citizens have for how the rules could better protect disproportionately impacted communities. First of all, we appreciate that so much thought has gone into drafting a really kind of careful and comprehensive definition of disproportionately impacted community. I think in terms of environmental justice and thinking about how to really kind of achieve some of those goals and better protections, it would be helpful to incorporate that definition in sort of a workable, more meaningful way in other parts of the rule. So the first one has to do with the alternative location analysis, looking at Rule 304B2AI and the applicability of the alternative location analysis. You know, we appreciate that it, you know, applies pretty broadly in many instances, and we would ask that in looking at those instances where an ALA might be waived, that in addition to the rule be made so that an alternative location analysis would not be able to be waived if the proposed working pad surface is within 2,000 feet of a disproportionately impacted community. You know, the current red line language, I think I referenced is, you know, at least a start and kind of the minimum. We think it's perhaps more protective if that rule is amended just a bit to look a little bit more broadly at if a proposed working pad surface is within sort of any edge of a disproportionately impacted community as well. And the second change that we would recommend would be looking at Rule 604B4, having to do with setbacks and some of the potential areas where there might be exemptions to the setback requirement. We suggest adding a Rule 604B4H under the list of criteria where the commission might hold a hearing on a proposed oil and gas location and determine that there are substantial, or there are certain conditions of approval that will provide substantially equivalent protections. And that list of criteria has to do with what the commission would then base its finding on. And we thought it would be helpful to just be very explicit about whether the proposed location would increase potential impacts on a disproportionately impacted community. You know, I think that's probably something that such a hearing, you know, necessarily would kind of invoke consideration of. But I think it would be helpful if the rule could be very explicit that that's an item that would be considered in such a hearing. And with that, I'm happy to take your questions, and I know you do probably want to get on with your deliberations, but thank you very much for your time.
Thank you. Thank you for your participation. Do we have questions from commissioners at this time? Okay, I'm not seeing any questions. Thank you again for your continued participation with us. We appreciate it.
Thank you very much.
Okay. All right, so we've concluded the closing statements. And for the record, we also have received, as we requested, closing statements from most of the parties in writing. Those 4-pagers were tendered and made available to everyone at about 8 p.m. this past Tuesday, and commissioners have read through all of that as well. So that influences the next steps, which is our discussion and deliberation. I have some just initial thoughts procedurally about how to tackle deliberation. The first thought and the best thought that I had was, rather than me trying to do a probably poor job of sharing screen and capturing ideas and looking at things, AAG Minor has agreed to be in charge of screen sharing and sharing notes as we develop up our issue list, and then as we move through things and sharing things. So all hands to AAG Minor for agreeing to do that. You will do a much more successful job than I would have. What I would suggest, so we have a lot before us. We have the 200, 300, 400, 500, and 600 series before us for deliberation over the next period of time. We also have engaged in a robust process to receive stakeholder input in numerous different manners over the course of the last 9 months or so, that has informed the rules that we have before us. And I think that the rules that we have before us are staff's 918 red line draft, as well as a clean draft. That, and just for everyone that is listening, that draft that staff came up with was not a draft that came out of the blue. And in fact was a draft that was fully informed by staff, because at the conclusion of each of the series, we had discussion and debate amongst ourselves as commissioners about direction to staff. And we had 5 different bucket memos. I'm looking for my bucket memos. They're here somewhere, that Director Murphy put together. And those bucket memos were PowerPoints that we created on the record, and staff, we identified issues, and we largely came to consensus, not always, as to direction to staff for the issues that were informed by the party presentations. And then we then directed staff to please go back and develop language for our consideration that is consistent with the information and the direction from this commission. I largely believe that the 918 draft is indeed a draft that reflects consistency with the direction that this commission gave staff on those various rules. I think this process has been remarkable. I think it has allowed for staff to engage with stakeholders as they develop this. And I believe that we have very successfully are getting to a place with these rules that will be a success for Colorado. I do think that these next few days of deliberations are going to be really important. So where am I going? So what I would like to do, and I would honor initial thoughts from my fellow commissioners, but I would like for us to potentially identify those rules that we think deserve kind of direct attention and deliberation. I say that because, at least in my opinion, the vast majority of the 918 red line I'm very comfortable with. I think that we've already debated through the vast majority of the 918 draft, and staff did what we asked them to do, which was to take our direction, incorporate our direction into the rules, and bring it back to us. And I also, for the record, believe that we did a phenomenal job of giving the parties an additional chance to debate with us, provide direction to us about the 918 draft, because we took an additional period of time before we got to today in the deliberation, and we gave parties 2 opportunities to provide closing statements around the 9/18 draft. The 4-pager that they filed by Tuesday, and then today's closing statements. So, I guess what I would like to do is let's identify the issues that deserve our attention. And I guess one of the things I'm also doing is that after we sort of debate through those issues, I would then want to take up, say the 500 series as a whole and see if anybody has any additional issues that, maybe you're not like at the highest level, but that you wanted to have some discussion about. And I'm suggesting doing that rather than starting at the 500 series page 1 and flipping through it page by page by page. I personally don't need to do that. I think we can capture this at a higher level. So with that, I think there are 2 areas that we should put on our list and we should discuss first. One is Rule 604, the setbacks rule, and the other is alternative location analysis, Rule 304B2. I think those are sort of tied in hand to hand. I could also put on the list Rule 507 standing and the 2 rules, 301F and 303A6, which is around local government coordination. But I don't necessarily need those last 2 on the list because I actually am fairly comfortable with where staff landed those 2 rules. So the 2 rules that I think deserve initial debate and dialogue are, again, 604 setbacks and Rule 304B2 ALAs. With that, I would turn to my fellow commissioners to provide initial perspective on sort of procedure, and if you're comfortable with this approach, perhaps you could add to the list that Mr. Minor will be developing for us. Don't be shy now. Commissioner Njapa.
Thank you, Mr. Chair. I would agree those are the large buckets for me as well. I would add, there's a few other sort of smallish things that we may kind of catch at the very end, I think, but I would, I did want to maybe at least touch on the Rule 218 transfer of ownership and just make sure that we were good on the details there. And then also cumulative impacts in, what is that, 314? And again, just making sure that we were good on the various aspects that are being requested there. I had a note for the sequential versus concurrent permitting in 301, but I feel pretty comfortable with, what the staff has so far and some of the additional comments that we've received, knowing that they have listened carefully and will be taking those comments into account. But I'll just flag that as something that we might want to note. And there were a couple of little loose ends, I would say, for me with the CIDR database, just again, making sure that we have what we want in that. Let's see, I think a couple of minor things for me within 400 in particular. I had a question related to 423 and noise, but other than that, I didn't have much there. And within 600, when we're getting into both the 604 and the alternative location analysis, I wondered if we might take a little time just to address some of the comments that we all received from the general public. I think there was a lot of maybe misunderstanding on certain aspects of, or how or what we decide, which we have not decided yet, will be, what kind of an impact that will have. So that's it for me.
Commissioner Gonzalez.
Thank you, Mr. Chair. I mean, the big one, 604, and I think the ALA that goes along with that is important to take on. So there's a handful of small things. I'm just going to run down my list, and I think some of them were captured by Commissioner Nanjapa, and I'm going to overlap, so I apologize, but hopefully AAG Minor can keep up. So I had a question for staff that I kind of want to explore a little bit further. The qualitative analysis estimate for incremental increase in pollutants in 303A5. I'd like to chat about the same kind of in the cumulative impacts plan under 304C 19D. Kind of the last part of that, kind of that broad catch-all language at the bottom, make sure that's dialed in appropriately. Let's see, 314E9, the ownership that was removed from the cap. I think there's some clarity that we can add there. Let's see, I'm curious about the additional time requested by CDPHE consultation in 309 F2A that I'd like to have some discussion on. 404D has kind of that equally or more protective language that I think lines up with what our discussion will happen on the substantially equivalent language. I think those both go to kind of that same standard question that we're going to be wrestling with. 507A2, I think we should talk about it. Came up in a lot of in a lot of closing statements. And then lastly, 218, which has already been covered. So that's kind of a high level hit list on what I've got.
Excellent. And I am unvideoing myself because I'm eating the second half of my sandwich. Other commissioners that would like to add or make comment? Commissioner McGowan and then Commissioner Messner.
Thank you, Mr. Chair. I just want to make sure that maybe we also kind of talk about what we mean by informed consent as part of 604 and maybe pieces of other rules.
Commissioner Messner.
Thank you, Mr. Chair. And I mean, it's all been hit. I just want to ensure that as we talk about cumulative impacts and cider, I'd like to chat a little bit about or better understand some of the removals for the cider requirements around wildlife and wildlife habitat, and kind of CPW's thoughts on that. And so I'd like to highlight that one as
well. Commissioner Putnam, did you want to add anything?
Thank you, Mr. Chair. I think mine have been covered. I think the main one that I had just to reinforce was 303A5 on cider. But I think Commissioners Gonzalez and Japa already hit that.
Okay, great. And I know that Commissioner Gibbs was with us and then had to do some other things. And so I'm not sure if he's here now. Commissioner Gibbs, it looks like you did unmute yourself. Hello.
Yeah, Mr. Chair. Yeah, nothing to add at this time, but thank you.
Okay, great. Thank you. Hello, AAG Minor. You have a document for us that you could share.
I do, yes. Thank you, Mr. Chair. I will go ahead and share my screen. That was, I think, a relatively easy set of notes to compile. So can you see that okay?
Yes, we can see that okay. It looks like it's at kind of the bottom of the page. Oh, there we go. Just patting myself on the back that you have agreed to do this as opposed to me. So that's great. All right. Well, do commissioners want to lead into a discussion around the first topic, which is the Rule 604 setbacks? I can start. I think that the language that staff has presented to us is a good place to be in general. I think that I'm supportive of the 2,000 foot. I think it's necessary and reasonable to protect public health and welfare, to avoid, minimize, and mitigate potential impacts. I think there's a substantial basis in the record demonstrating the potential for to protect public health and welfare impacts within 2,000 feet. I also like the soft setback component. And I think it's necessary to avoid potential health impacts determined by the 2019 CDPHE public health study, and to avoid potential impacts to public welfare by setting a default placement of oil and gas facilities at a distance where noise, light, and odors are not as disruptive to the relevant receptors, i.e. people living nearby. I think it's reasonable, because it's not greater than the evidence in the record and it's supported. I think we should have some discussions around the substantial equivalent language. I think we received a lot of comment around that. And I have one minor subtle edit, which is, did we mean to not include tenant in the 500 foot setback? So right now it says building unit owner can waive. And in other instances, we've actually included tenants in that. And so that would be the other point there. So I'll look to my fellow commissioners for thoughts. Commissioner Gonzalez.
Thank you, Mr. Chair. I appreciate your comments. One thing I want to talk about is the siting requirements in 604B, and I think those are really, really important tools that we have to protect in that kind of 500 to 2,000 foot range, and I think that we're in a workable spot there. I have said it before, and I'll say it again. I don't like the idea of calling setbacks soft. I think there's setbacks, and then there's there's extra protection, extra scrutiny. And I like the idea of siting requirements. I think that adds a higher level of siting scrutiny and of siting effort and of siting hurdles for the industry. And I think that they are I think that the way they're drafted currently is in a very high level and will provide that scrutiny and that protection. One thing I'd like to offer for 604 is to, in the heading, call it setbacks and siting requirements, to really capture the nature of what that language is. I think it's important that our rules be clear and that we provide certainty for the actual impact of those rules and how they're going to be interpreted in the future beyond just this 5-member body. And I think that go a long way to clear that up and to really establish the intent of these kind of soft setbacks that have been proposed by this commission. So I'd like to throw that out there. I'd also like to address the substantially equivalent language. This is something I've been thinking about in conjunction with kind of the equally or more protective standards in the 400 series that have popped up. Is our standard is set by the statute, and our standard is for every decision that we make, and that is to protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources. And in my mind, that's the standard that should apply to every rule, and to kind of pop in different standards here and there that are equally or more protective or that are substantially equivalent, take away some of that clarity and some of that certainty. And I think it kind of takes away our nimbleness as a commission to really understand and apply what we know on a site-specific basis to best protect and minimize those adverse impacts. So with 604, I'll kind of leave it there and let the other commissioners chime in.
Other commissioners desiring to chime. Commissioner Najapa.
Thank you, Mr. Chair. In general, I am comfortable with much of what Commissioner Gonzalez has said. The one thing that I am less comfortable about, which, I also agree that within this framing that we have here, we're sort of 500 feet becomes the harder setback. I'm less comfortable with 500 feet. I think it's important that we have some of the flexibility in that area beyond, where we can allow for certain circumstances depending on, technology or other limitations, geology, et cetera. But I'm less comfortable with 500 feet as a minimum. So I'll put that out there for continued deliberation and discussion. The other thing that I was thinking about and related to some of the closing statements that we received and heard today is that given, that we are, our mission is to protect public health, safety, welfare, and the environment and wildlife resources, I'm wondering if there might be some value in a slight rewording so that it's not unless one or more of the following are satisfied, but rather unless one of, 1 through 3 and 4. Because I think number 4 is particularly important as it relates to our mission and also the ability for us to have a hearing when we have instances of requests that are going to be less than that 2,000 foot boundary.
I see AAG Minor is capturing that point. Other commissioners with.
I just wanted to.
Go ahead, Ms.
Just a quick clarification on that. I was thinking just an and specifically for number 4, but ors between the others. So 1 or 2 or 3 and 4, if that makes sense.
Commissioner Messner.
Thank you, Mr. Chair. And I'm going to apologize in advance because my thoughts are a little scattered on this right now. And so I'm going to just talk and I'm going to ramble a little bit. I'm apologizing in advance if I'm not totally coherent. First of all, I would agree with Commissioner Nanjapa that, in 604, having some discussion and just clarity around which one of those items actually incorporates a hearing process. I've got a certain interpretation as far as I read it, and I say that even if there's informed consent, there still has to be a finding within the oil and gas development plan hearing in order to confirm that there is that informed consent. And so, that would be the hearing process for the informed consent piece. I also look at some of those other ones in the same light. And so I'm happy to continue. I'm actually happy to hear from staff on that one, just to make sure that I understand intent and what the processes are for each of those items. And so I think that's good to talk about that. And if that is true, my interpretation of that, then I'm not sure there has to be an and to go into 4, but I'm also open to that conversation. I also appreciate the comments that Commissioner Gonzalez has brought up. I do think over the last week or 10 days, there's been, a lot of posturing, a lot of rhetoric. I think sometimes the truth gets lost in the posturing and the rhetoric around calling what we've been discussing and talking about, the same as Proposition 112. It clearly is not that. I think anyone who actually looks at or has listened to what we've been talking about clearly knows that it's not that. I look at this closer to the discussions and interpretations and applications of the director's criteria. I think that was within 2,000 feet. There was going to be more scrutiny. There was going to be more best management practices, technologies, techniques, mitigations necessary in order to be able to approve oil and gas locations within that 2,000-foot boundary. I think this is, in some respects, an attempt at codification of the objective criteria, the director's criteria. And so I don't really appreciate the posturing on that one, because that's not been the conversation that we're having. And so I am interested in continuing to have the conversation about it. I do think, as I have looked at all of the testimony, all of the statements, all of the information that's been provided over the last, months, and I'm not kidding when I'm saying that I have read dozens, and that's plural, dozens of studies, not just one or two, dozens of studies talking about potential public health impacts or not of oil and gas operations. And so, I've read all of them. I've analyzed all of them. It's not one or the other. It's not one person refuting the other that is making the determination here. I've got a clear body of evidence that I'm working from experts from multiple different stakeholders that I'm utilizing to make decisions on whether or not there's potential public health impacts from oil and gas operations. In addition to public health impacts, I'm also talking about public welfare impacts, right? And so these are perhaps some of the nuisance items. And so it's not one or the other. It's the package that we're talking about here as far as looking at how we determine where we're siting oil and gas locations within the state of Colorado. And so I'm very comfortable with where we're at. I do think there needs to be some additional discussions about substantially equivalent. I think there needs to be a deliberation amongst us and perhaps some clarity within the statement of basis and purpose as to what we mean when we say substantially equivalent, to ensure that at a minimum, all 7 commissioners know what it is when we say substantially equivalent and how one would apply that as we're reviewing applications. I do think protect and minimize is inherent in the act, but I don't think that captures the additional siting requirements that are going to be in place should an operator choose to pursue a site within 2,000 feet. And so I think that the utilization of substantially equivalent makes sense. I think clarity and discussions around what that means. I mean, substantially equivalent, substantially similar, no net adverse impacts. These are standard terms utilized in land use processes across the state of Colorado, across the country. So it's not foreign terms. These are clear terms, and a lot of times in land use, these terms are defined in the state of Colorado process. They could be either defined in the rules or they could be clarity in statement of basis and purpose, and I think we can accomplish that. But for me, what that says is the same thing as the director's criteria is should you choose to pursue a site within 2,000 feet, then you are going to have to utilize more mitigation measures to avoid, minimize, mitigate. You're going to have to use best management practices, different technologies and techniques and substances and whatever those are. And those can evolve and be performance-based as far as determining what best application can be utilized in site-specific situations in order to meet in order to be as protective as if you put it at 2,000 feet. And so that's where my mind goes with that. And I'm happy to, have that challenged and talk about it in order to make sure that we're all clear, whether that's a good idea or a bad idea. But I just wanted to throw that out there. And I think that is the same with the utilization of the term, net adverse impact. I'm continuing to go through my chicken scratch notes here. I apologize. And so, yeah, I'll leave it at that for right now, and we can continue to have the discussion. But I do think that it is what we're talking about here is applying SB 19181 based on the significant amount of science that we've received in order to determine how we're going to site oil and gas locations in the state of Colorado. We're not precluding oil and gas operations in the state of Colorado. We're looking very closely as to performance-based land use process. This is land use processes that get utilized, oftentimes around the country. And so I think there's a way forward here in order to be able to, have these protections in place and still have the ability to cite successful oil and gas operations. So I'll leave it at that for now.
Thank you, Commissioner Messner. Commissioner Nanjapa.
Thank you, Mr. Chair. I just wanted to just quickly piggyback onto Commissioner Messner's comments, in that I did want to address, some of the stuff that we had received, some of the important comments that we'd received from the public. But in particular, and I wanted with AAG Minor on the line here to be able to confirm, there was a lot of discussion about, folks who are currently receiving royalties from producing wells and the impact that our decision making here would have on that. And my understanding is that if there is an existing producing well and that folks are receiving royalties from that, this doesn't change that. Whatever we decide in these next few days or weeks will not affect that directly in terms of taking wells out of commission. Is that correct?
AAG Minor.
Sure. Thank you, Mr. Chair. And I'm happy to answer that question. And of course, I am providing staff's perspective on that legal issue, and Mr. Davenport can always provide the commission's, his perspective as commission counsel. You are correct that Rule 604 is a prospective rule. It is about the siting of future facilities. So it would not impact royalty payments being made from existing wells that have already been sited and are already producing.
AAG Davenport, would you like to add anything as our attorney?
Just that I agree with Mr. Minor, it's a prospective rule only.
Commissioner Nanjapa, a follow-up?
Just thank you for that response. And I think I just had one other bit, but if Commissioner Gonzalez was going to add to that particular topic, I'd defer to him.
Thank you, Commissioner Nanjapa. Thank you, Mr. Chair. Yeah, no, I mean, I think that AAG Minor and AAG Davenport are absolutely right. That it's not going to affect the royalty stream and the royalty revenue that mineral owners are receiving on currently producing wells. I think that there's a big misunderstanding by anyone who does not participate in having royalties or work in the oil and gas industry, that when a well's drilled and that royalty comes in, that's some sort of constant stream of revenue. Oftentimes, the royalty revenues that are received are front-end loaded, because with the nature of some oil and gas wells, the production occurs in the very near part of the well itself, and then it's a kind of tables off and then dips down and kind of goes on along its limit on the x-axis there. I think where the concern is, and where some of the public comments also made note of, is that they're relying not only on the royalty streams that they're receiving now, but on the undeveloped mineral royalties that they plan on receiving in the future. And that's a big deal, right? When you think about, maybe getting a check that's a, $10, $20, $100 here and there for an existing well, but then you have the opportunity for future development on your mineral rights, on your mineral property rights, and that's going to provide you potentially $1,000 or $2,000 check that's a little more substantial for whatever your future endeavors are, and however you choose to monetize and to use those funds that are generated from one's mineral private property rights. And so that's where I want to make sure that distinction is known, that just because someone's receiving a check doesn't mean they'll always be receiving a check. Just because someone's receiving a check now doesn't mean that check is going to stay at that same amount. And it's really important to remember that it's the future development of those mineral rights and those mineral properties that a lot of people are relying on for their own public welfare.
Thank you, Commissioner Gonzalez. Commissioner Nanjapa.
Thank you. Thank you, Mr. Chair. And I appreciate that comment from Commissioner Gonzalez in terms of kind of how that works. I had a couple other follow-ups, but I don't want to hog up all the time here. But the one other piece that I just wanted to note was Commissioner Messner also raised about the topic of Proposition 112, and we heard that from a lot of folks commenting. But that was a very broad, sweeping proposition that included sort of all sorts of situations, waterways, a whole lot of additional conditions, and what it's like using a machete for a haircut. And we are not talking about that. We are talking about something a lot more surgical, with a lot more discussion about certain situations that might require something a little bit less than, and these various considerations. But I also want to emphasize what Commissioner Messner also touched on in that I've also read a lot of these studies, and while I think the BTEX, the benzene and those kinds of VOCs, volatile organic compounds, there's a lot of, it's true, a lot of the data doesn't show much beyond 500 feet, but there's a lot of other impacts that we don't know as well. There's not enough direct data to support whether those kind of longer term, that's more, a lot of those measures were at acute levels and not chronic levels, and looking at, we don't know as much about how those impacts, come into play over longer periods of time, because we don't have those long-term data sets quite yet. But that growing body of evidence is really what also shows me that there is a greater distance, and this is why I'm saying I'm not comfortable with 500 feet as a minimum. I think we need to go beyond in order to protect public health, safety, welfare, and the environment. And I think that that's where I'm coming from, because especially when you couple it with the nuisance issues, the public health specific considerations with these VOC and BTEX type studies are just one piece of this overarching consideration with respect to impacts on the public health, public welfare. And so I think those are important considerations. And then the last thing I'll just say is related to the royalty payments. I think the one thing that at least I have observed over the last several decades is that the oil and gas industry is, if there's one word that would describe them, is that they're innovative. And that if right now there's not a way to access mineral resources at 2,000 feet, there probably will be at some point in the future, or there's maybe different technology that can be applied or implemented. And I think we see that where there were areas of the state that were just completely thought to be no longer valuable, inaccessible, and now they are. And those mineral rights, were once valued very low, and now they have more value. And so I think that's something that is also, I think, a consideration for all of us.
Thank you, Commissioner Nanjapa. Commissioner McGowan.
Thank you, Mr. Chair. Sorry, and my child just came home, so the dogs might get a little excited. So a couple of thoughts, and it might be rambling, similar to Commissioner Messner, and I apologize because I feel like I have a lot of things that I want to ponder and talk about, and they're not necessarily in order. The first is that I think that a lot of folks have shared a lot of good studies and good data, whether it's toxicological, epidemiological, observational, and I think that the jury is still out as to the exact things that are correlation versus causation. But I think we do know that things are being released via oil and gas production that do have acute health effects on people. And I think that some lived experience that has been shared with us, things that have been called into the Department of Public Health and Environment as far as the health effects that people have experienced, show that there is a health effect on people. And then to everybody else's point, we're supposed to be looking at more than just health. Everybody testified about mostly about health today and not about the welfare aspect, which is also lived experience, and I think also can affect mental and physical health. If you're experiencing odors, noise, light pretty constantly, I think that that also has a health effect on people. That being said, I'm comfortable with the 2,000-foot setback with what I guess I'm considering off-ramps for industry, because I will say again, the setback it's a blunt instrument, but it's the instrument that I think explains the best from a commission's perspective. We want to see oil and gas activity further than 2,000 feet, but we also understand that's not going to be possible in all instances. That there will, I'm going to call them special snowflakes. There will be special snowflakes, and we have to provide an opportunity for folks to show why they are a special snowflake. So why they are unable to have their operation be 2,000 feet away. I would like us to talk about what substantially equivalent means, because if we're saying that it means the exact same thing as being 2,000 feet away, I think we're setting a standard that possibly is not achievable by industry or an operator. So I guess for me, noise would be a good example. The further you are away, the less noise you're going to hear if you are further away from that. So what do we really mean by substantially equivalent? And in my mind, you're coming to the commission and you've got a really stellar application put in front of the commission that shows you've been very thoughtful about all of these other pieces that we've asked you to consider besides just the setback. The setback is one tool that we've put forth as a commission. We've put forth a lot of other things or tools or considerations that we want an operator to also show us. We want to see best management practices. We want to see collaborative and meaningful community engagement. We want to see alternative location analysis. And I think all of those things, if we wrap them all together, I think will result, hopefully, everyone will see thoughtful decisions by this commission for folks who cannot meet the 2,000-foot siting that we've been discussing. The 500-foot setback, and to Commissioner Nanjapa's point that she's maybe not comfortable with 500 feet, if I'm understanding what we've put forward, if you want to be within 500 feet, it's the informed consent of the building owner. And I guess my thought is, if you're the 500-foot example, you're potentially dealing with very few property owners who are making decisions about their own private property rights. And I guess I'm comfortable with those folks making that decision for themselves. And maybe I'm misunderstanding kind of what our thought was about the 500 feet. Sorry. I will stop there.
Thank you, Commissioner McGowan. And I would kind of like to echo off of those thoughtful comments that you made about substantially equivalent. I think that I agree with you. I think that the 604B4 off-ramp does establish that it's not just that siting is the sole or predominant tool, or that the distance is the sole or the predominant tool. And I really appreciate the work staff did to make, 1, 2, 3, 4, 5, 6, 7 of a non-exclusive list of things that when you combine them together, you can approve a location that is closer than the 2,000-foot presumption because it is substantially equivalent. But that doesn't mean that you will always have the same protections as at 2,000 feet, because you're using these other tools to, in some, provide a location that is as good or better as just a presumptive use of 2,000 feet. And so I just wanted to echo off of that. And I guess I'd like to say on the record that if we adopt this setback and siting requirement in some form as it is right now with some adjustments to substantially equivalent, I for one am not a commissioner that is adopting off-ramps that are not proposed to be used. I believe these off-ramps should be used, and they should result in snowflakes that are special getting approved. I never knew of that term before, Commissioner McGowan, so I've learned something today. I thought that all snowflakes were special. Like, there's not two snowflakes that are the same, right? They're all different, but some are more special. And so, I mean, I believe that this is a very well done tool that recognizes the other tools that exist within our proposed regulations, the 400 series on noise and odors and things, and recognizes that it's not always the most protective to just be a certain distance away. And so I believe that these off-ramps do establish that we will be in a place to adjudicate wells that are closer and that those would have approvals. I similarly believe that this body is going to be in a place where we may get a proposal that we look at it and we suggest that that's not necessarily going to be substantially equivalent. And we don't think that that is something that is approvable. So I think I'm really proud of staff and the draft that has been presented to us. And as I started, in large part, I'm comfortable with where we're at with regard to this. Do we want to, oh, go ahead. Did someone else raise their hand? Commissioner McGowan.
All right, thank you, Mr. Chair. Could we talk a little bit about what we mean by informed consent? And maybe it's okay because both parties seem concerned about it. One party seems concerned that informed consent would mean that one person could hold up an entire proposal, even if it was a very good proposal. And the other side is worried that informed consent would be potentially buying people off or them not really understanding what they're signing off on. So could we talk a little bit about, maybe this is a term of art that other folks are familiar with, but I would like to know kind of maybe what we're thinking about here.
So I might turn this to either of staff's attorney AAG Minor or our attorney AAG Davenport. In the draft that we received from staff, the term informed consent was placed, but there was not, help me if I missed this, but I don't believe that it was further defined. And it's something that we could define, attempt to define on the record today. It's something that I believe that our AAGs could put into the statement of basis and purpose. And when we come back to a final vote on everything, we would have that in front of us and we can review it. Director Murphy just showed up, shows she's paying attention, which she always does. Did you want to comment?
Chair, that was going to be my comment, is that we've gotten the feedback and we think that it's something we'd like to address in the SPP, and then also kind of in this overarching best community practices document that we want to prepare for meeting. I mean, I think that there's kind of this broad swath of community engagement, but this entirely is with all the other pieces or your choices.
Do either of the attorneys want to weigh in at this point? And you don't have to.
Mr. Chair, I think I would just say that, as I believe you noted, there is a deep body of case law about the meaning of informed consent in various contexts under Colorado law that I think could be drawn upon in the Commission's own interpretation. And then I'll let Mr. Davenport elaborate on that if you'd like to.
I don't have anything further. I think enough has been said at this point that I agree with. So.
Commissioner Messner, then Commissioner Nanjapa.
Thank you, Mr. Chair. So if I wasn't clear, I'm going to try to be a little more clear. That before we jump into informed consent, I want to kind of keep going here on substantially equivalent. And I don't want to beat a dead horse, but I do think it's important on the record that we all are clear about how we're interpreting what substantially equivalent means. And I do concur with Commissioner McGowan, Commissioner Robbins, that to me, substantially equivalent doesn't mean that distance is the only way to avoid, minimize, mitigate adverse impacts. And so I do think that these off-ramps are developed to be utilized. That doesn't mean that every application should utilize the off-ramps. The way that I look at it is that if I'm an operator and I have the ability to site this site at 2,000 feet and I don't want the additional headaches, expense, and information necessary to be provided to accomplish something that's inside of 2,000 feet, then why wouldn't I site it at 2,000 feet? It doesn't make any sense to not site it there. However, if it is technically infeasible, or if there is another reason that it should be attempted to be sited within 2,000 feet, then that's why we have the off-ramps to be able to do that. And I think that then the mitigations, the best management practices, the techniques, the technologies, in order to avoid, minimize, mitigate these adverse impacts, just continue to get more significant. I think the closer that you come in a proposed location. And so I agree. I mean, to me, like I indicated before, this is really similar to how things got evaluated through the director's criteria, the objective criteria. And, I do think that having some language in there that is clear that at 2,000 feet, one can assume, because distance is the greatest mitigation, in many circumstances, that as you come closer, that you need to understand that you will have to provide more and more mitigations as you come within that. And I think the term substantially equivalent does that. I think with the two prescriptive items, whether that's, and the two that are off the top of my head are lighting and sound, I do think that, to me, what the substantially equivalent means is that it meets that standard. These are prescriptive standards, so it either meets that standard or it doesn't meet that standard, irregardless of where it is. If it's at 2,500 feet, it still has to meet those standards. If it's at 1,200 feet, it still has to meet those standards. And so those are the two that are prescriptive, but I think the other pieces, are more performance-based, and, the burden of proof would be on the applicant to show that their plans, their best management practices, their technologies and techniques would accomplish substantially equivalent protection. So I just wanted to be clear as far as where I was at on that. Oh, and one other thing before I stop rambling. I do think there is some merit to consider, and I'm not pushing this, but I do think that there's some merit to consider the language that was suggested. And I think what I heard from the Western Rural Local Government Association agree with, that having findings within 604 that would be that if it was technically, you'd have to have a finding that it was technically infeasible to recover the targeted minerals in order to be able to go within 2,000 feet. And that it was there wasn't a reasonable intent, and I'm paraphrasing here, there wasn't a reasonable attempt to obtain informed consent. And to me, those make some sense. I actually think it gives some protections to operators, that they are making a showing that they certainly did the analysis in order to be able to site this outside of 2,000 feet, and it was technically infeasible for them to be be able to do that. They made an attempt at waivers, and perhaps it was not possible to accomplish that, but that it could still at that point be considered with additional mitigations within that 2,000-foot sighting boundary.
Thank you, Commissioner Messer. Commissioner McGowan, then Commissioner Gonzalez.
Thank you, Mr. Chair. I'm maybe interested in that kind of concept also, but I also think that we don't need to reinvent the wheel. 502 already has language. It has made a good faith effort to comply or is unable to comply with the specific requirements. So maybe if they've made a good faith effort to comply or unable to comply with the 2,000-foot sighting, that they would have to show why that is. Is that the same thing, or is that too broad?
Commissioner Gonzalez, did you want to weigh in?
Yeah, I can jump in right there. I read 502 and the hearing under 604 to be very different. Hearing under 604 is an evaluation of the OGDP, the Oil and Gas Development Plan, and the 510 hearing mechanism is the mechanism for that. And if you're within all the citing requirements under 604 and you can meet them and you are going to a hearing, you've given proper notice, you've got the appropriate parties tied to that hearing, it's, to me, doesn't seem like it's a variance from the rule. It is complying with the rule and therefore shouldn't be a variance hearing. So that's the difference between 502 and 510 in my mind, because if you comply with the 604 B 1 through 4 or what have you, then you're within the scope of the rules. You're not asking for a variance from the rules. Yeah. I'll let AAG Minor or AAG Davenport chime in and tell me I'm wrong here, but that's kind of the way.
Commissioner Gonzalez, I wasn't asking for a variance hearing. I was saying there's already language in 502 that might be similar to the language we were just talking about.
Okay, I'll go look at that.
Commissioner Messner.
I was just going to ask Commissioner Gonzalez what he thought about those two items and whether he thought that was a benefit or not in the 604 process, acknowledging that would go through a 510.
Which two items, Commissioner Messner? You're on mute.
The showings or the findings that it was technically infeasible to recover the targeted minerals at 2,000 feet or greater, and that they made a reasonable attempt to obtain informed consent through a waiver process. It seems like inherent in an application, if they were trying to suggest a location inside of 2,000 feet, they would make those showings or findings anyway. But I guess I was curious for your thoughts on that.
Yeah, I think that would be something that we as commissioners could ask for in our hearing, right? And say, hey, what did you guys do? Why are you within 2,000 feet? And that kind of goes to another point that Commissioner Nanjapa brought up that was interesting about having the kind of the 1, 2, 3, and 4 under the 604B. And I think that we have the opportunity to ask and really to push industry and to make sure that they have made these evaluations and to do so in a public way, in a public hearing and under oath, right, in testimony, where they're going to be expected to present information like that in order to allow us, in order to put us in the best position to make those determinations on public health, safety, welfare, the environment, and wildlife resources.
Commissioner Nanjapa.
Thank you, Mr. Chair. And yeah, thank you, Commissioner Gonzalez, for mentioning that. Again, I do think that's an important piece. It sounds like, and correct me if I'm wrong, AAG Minor, that the way that it's currently written with the 1 or more, there's the informed consent or the comprehensive area plan or the location of the equipment or a hearing. And I'm thinking that we would want the hearing if we are specifically considering locations that are within 2,000 feet. And so maybe before I get further into that, I just to clarify that, is that what that current meaning is that either it's this or that, or 1, 2, or 3, or we have a hearing?
The way I read that, Commissioner Nanjapa, and I'll let AG Minor tell us his perspective as well as Director Murphy, is that 1, 2, or 3 did not contemplate this additional specific finding under a Rule 10 hearing that is the finding 4. But those wells would still come to us and be approved under an OGDP at a hearing. But as I read it, the additional components of substantially equivalent protections that is found within 4 are not necessary if you're trying to get off-ramp 1, 2, or 3. Director Murphy or AAG Minor, would you like to chime in?
Chair, I'd like to say ditto, and then turn it over to AAG Minor if he wants to add more color commentary.
Thank you, Mr. Chair and Director Murphy. That is correct, that there is a commission hearing on every OGDP application, regardless of whether Rule 604 is involved. So there would still be a commission hearing on something that meets the criteria of subparts 1, 2, or 3. And of course that hearing could be the consent agenda, it could be an actual hearing, it depends on other aspects of the 500 series and the 300 series. And so the inclusion of that language in Rule 604B4 does not mean there will not be a commission hearing for the others. It does mean that there would not necessarily have to be a specific commission finding at a hearing that those criteria are met. They're sort of more fact-based criteria. Is it within an approved cap or is it not? It's not sort of a determination that the commission would have to make.
Does that answer your question, Commissioner Nanjapa?
Yeah, thank you so much. That does. And I did have one follow-up, if I may, Mr. Chair.
Yes.
So this is more just in terms of our overall discussion. I think I've been thinking about this informed consent piece, and this was raised in some of the comments and in closing. But I want to make sure that we're thinking about kind of what that means to be informed. I think we had some good suggestions in some of the definitions that were provided, and whether or not that actually becomes a definition or goes into the SBP as was suggested. Obviously I would defer to staff, but I think it would be useful, or at least I would want to see in whatever comes to us in a hearing, the efforts made with respect to informed consent. So, what was the specific engagement? What types of matters were discussed in order to receive, were there any discussions about if we consent, we'll provide, you will provide this, or vice versa. And so I think that would be just a useful piece that I just want to make sure that we're addressing in some way, whether it's a form that we now require for informed consent that asks certain questions, or that that the guidance that's issued is, includes some of that information. And I think there was at least one bit of testimony in the closings today about having those landowners potentially participate in those hearings, so that we could also ask them questions, which I thought was interesting as well. So yeah, as we talk about informed consent, I just wanted to think through that a little bit, because there's sort of one way to be informed is just to know that something is going to happen, but another way to be informed is to really understand what you're sort of agreeing to, what you're getting into. And that was, I think, the analogies that were made with sort of medical procedures, et cetera, were helpful. I know AAG Minor mentioned there's a lot of case law there, but I do want to just be really sensitive to that as we think about the potential for certain folks to be taken advantage of if they're not, well, I shouldn't say taken advantage of, but to not be properly informed if there were not good guardrails.
All right. So we've kind of danced between substantially equivalent and then over to the other dance of informed consent. We've got a couple other things on our list or other sub dances that we need to get into. I'm just trying to sort of frame discussion. It's 4:12, and if we could get through this issue this afternoon, I think that would be a good place to get through today. So maybe what we could do is we could, and I'm looking at the rule itself, so maybe if we just start at the top of the rule and roll through it, and then we can address the issues as we get through them. And so if that's the case, then I've not heard any concern with 604A, basically, except for 604A4, and that's the concern that Commissioner Najaba has brought up, is the 500 the right number there. So thank you, AAG Minor, for moving to the actual rule. And let's get to that. Yep, there we go. And so with that, and so this is a clean version. I'm working off the red line, but that's fine. So I'm not seeing any concerns with the edits that were made around the removal of, or that the school facility, child facility shall be firm at 2,000 and will not be waived. So it seems like there's consensus there. Someone do like this if you disagree. I'm just going to keep rolling us through this. And Commissioner Nanjapa, did you want to say something?
I just wanted to know, I think that today we heard from La Plata that maybe some of the like nursing facilities or those sort of long-term residential facilities might be something to include here. I didn't know if other commissioners had thoughts on that. I thought that was a reasonable suggestion.
Do other commissioners want to jump in on that? Commissioner McGowan.
I'm not sure I have a feeling about it one way or another, other than it is a vulnerable population. The difference, I think, for me being that a nursing home facility might be privately owned. It's someone's private property again. And so to me, this is kind of intertwined with informed consent, things closer than 500 feet, someone making a decision about their own property versus, and then also tied to, someone brought up, do we want tenants to have a say versus just the property owner when we're talking about some of these decisions? And I don't have an answer, but to me, those are all kind of, they kind of tie together a little bit as far as this kind of who owns what, and then who has say, or who, does that make sense?
I think that does add some value around this discussion. I do know that the school facility child care center definition was debated vigorously in the school setback rulemaking. And I also would note that even if that type of facility is not included in the, you will never be 2,000 feet or less, the other siting requirement off-ramps that we have do establish to us discretion under paragraph 4 And I think we could use that discretion because those would obviously become a high occupancy building unit. And then I think getting to the point you made, Commissioner McGowan, the only other off ramp there is in paragraph 1, the high occupancy building unit owner and tenant all agree. And I think it would be difficult to get all of the owners and tenants of, say, a facility such as was described to all agree. I think that would become a very difficult thing. So I think the protections, at least in my mind, are built in without having to call it out. And I tend to agree with the points that you're making, Commissioner McGowan, about that. Other thoughts on this area? Commissioner Njapa.
Just a clarification. I just went back and looked at the closing statement, and the request was more related to residential building units. So I made an error there in suggesting it was similar to the child care facilities, but I think there is, yeah, I think that was perhaps that's already. I think it had to do with the threshold for what determines a high occupancy building unit, being 50 or more persons, where some of those facilities, nursing type facilities, are going to be less than in some cases, especially in rural areas.
Yeah, I think that's right. And AAG minor or AAG Davenport, what's our definition for high occupancy building?
Mr. Chair, I just called it up on the screen so that everyone can see it. It appears at the top of the 300 series draft, just because that's the first place in these rules that it's used. So that's called up on the screen for everyone to read. I am fairly certain that subpart A and B were not modified at all in mission change, except perhaps for citation formatting. Subpart C, I believe, was modified, but that should help.
Thank you, Commissioner Messner.
Thank you, Mr. Chair. And I would agree that I think there are protections in place for those circumstances. And I'm not sure it needs to be called out specifically in 604A3. I do, though, think that 604A4 does need to include tenants. You're going to have that. And I understand Commissioner Nanjapa's concern about having a essentially no service occupancy at 500 feet or less without informed consent. And what I think I hear her saying is that she would like to see it more than that. I've certainly heard from stakeholders that they would like to see it more than that. I do think that the review process for in 604, in order to be able to review applications within 2,000 feet, is certainly going to make it more difficult, if not near impossible, the closer you get to the receptor. And so I'm comfortable that through the application process, through the review process, that there will be protections in place to not allow certain operations. Not allow is not the right term. I'm certainly comfortable being able to say that the level of protections that are going to be necessary, the level of mitigations that are going to be necessary to put a site, within 700 feet of, 50 homes is going to be a very, very, very high bar to beat. I'm not sure that it is a beatable bar. And so, those I think are inherent in the protect and minimize public health, safety, welfare, and the environment. I think those are inherent with substantially equivalent language. And so I'm not sure that it needs to be different than that in there, although I'm certainly open to conversations around it. But I do think that that number 4 there does need to include not just the owners, but the tenants.
I agree with the tenant addition. Commissioner Gonzalez?
Yeah, does staff have was that an inadvertent exclusion there, the tenants?
If I may, Mr. Chair.
Yes, AG Minor.
That exclusion was in fact inadvertent, and staff would be supportive of that. It sort of reflects the interplay with the addition of tenants in B and maybe not getting them into A. So that was oversight on staff's part.
Okay, so I believe we will insert or tenant into 4. Do others have thoughts about that being a number of 500 feet? I guess I just would sort of throw out, and maybe this is for staff, if you look at 604A4, and it says that no working pad surface 500 feet from one or more residents unless there's a SUA or waiver that includes informed consent. And then B1, residential business use units owners and tenants and high occupancy building units owners within 2,000 feet explicitly agree with informed consent. Is the distinction there the surface use agreement?
No, Mr. Chair. The distinction is that here I'll combine the pages so you can see them. Is that A4 applies less than 500 feet, whereas B applies between 500 and 2,000 feet.
Yeah. Okay, I see that. Okay, are folks comfortable with A4 with the addition of or tenant? Commissioner Putnam.
Thank you, Chair Robbins. I had a question whether it should be an or an and maybe all owners and tenants. I would think it would be odd if we're trying to protect a tenant that an owner could waive, or that a tenant could waive the rights of the owner in that case.
So you would advocate for and tenant, is that right, Commissioner Putnam?
Yeah, I might say all owners and tenants. Given that you could have multiple owners in some cases and could have multiple tenants.
From all building unit owners and tenants. I think I'm comfortable with that. Others?
Mr. Chair.
Yeah, AG Davenport.
Thank you. I'm sorry to interrupt here. I want to talk about something that I think was raised at some point. There was a question raised about the intent of the rule and whether or not both the surface use agreement and the waiver must be from the building unit owner and the tenants. I think some parties may have read that rule to be so that as if only the waiver requires informed consent from the building unit owners and tenants. And to make it clear, I propose that we insert a comma after the word waiver to make it clear that both the surface use agreement and the waiver must be from the building unit owners and the tenants and have informed consent. And I would welcome both AG Minor or Director Murphy to chime in and confirm that was staff's intent. And then obviously that changes up to the commission.
We've lost Director Murphy for just a bit.
I'm sorry. Mr. Minor?
Mr. Minor?
Yes. Thank you, Mr. Chair. I am getting real-time communication from Mr. Jerron Lowe, who perhaps we could also zoom in, but I believe that is indeed staff's intent. So I believe that staff would support the comma. I just need a moment to confirm that with Mr. Jerron Lowe. Though I don't think you would get a surface use agreement from a tenant.
No. I don't think a tenant has the capacity to do a surface use agreement. They don't have requisite ownership rights.
I agree with that.
And however, there is also a nuance that the surface use agreement would only be from the surface owner. So if there is a surface estate that is owned by another person, then the person who owns the surface estate where the well is, where the location is proposed within 500 feet, that person would, there could be an owner of a building unit that is not also a surface owner. I think I may have made that more confusing than I intended to. I apologize.
All right, I think I'm comfortable with this edit. Are other commissioners okay here? Seeing none, I'm just going to keep moving us down the page. So that gets us through 604A, right? So now we're in 604B. I guess we don't have the list of topics, but let me just raise a topic that I heard from some of our commissioners, which was to, between one, after one put an or, after two put an or, and after three put an and. And what that does to my lay brain is it means that if you qualify for 1, 2, or 3, you also have to convince the commission at a hearing that you're substantially equivalent protective. AAG Minor or Mr. Davenport, is that correct in what sprinkling of ors and a new and would do?
I can start if it's helpful, Mr. Chair. That is mostly correct. I think the one thing it would also do is require the commission to make a finding under B4 and consider those factors for a location that perhaps otherwise it would not have had to, because it met one of the other criterion. So as written, there would be not a commission hearing with the factors considered for something that all building unit owners and tenants had waived, that was subject to CAP pre-application siting approval, or that was located farther away from sort of the highest concern equipment. So by adding the and, there would then be that commission finding in every case, which may not have occurred absent the and.
Okay, and so with that explanation, I'm going to provide my perspective on this. I appreciate the fact that you put those things in brackets because I would like you to remove them. I liked the balance that was created with the staff draft, and here's why. So with regard to 1, this is recognizing private property owner rights, surface owner rights who may be a mineral owner, et cetera. But if they, all of them and the tenants agree after having informed consent that it's okay for the location to be closer, I don't necessarily believe that we need to have a B4 finding hearing from us. I think that is an appropriate balance that is part of this siting and setback rule. With regard to B2, this is something that we have approved, that we will have looked at under a comprehensive area plan or an already approved comprehensive development plan. If it's an already approved CDP, I think we should honor that. I think there's one out there with preliminary siting, the Noble one, and I think we should honor that as a commission. If it is a CAP, that's something that we're going to have looked at anyway, and we will have made the judgment calls on the preliminary siting as to whether a strict 2,000 is always necessary or whether under our discretion we think that the CAP is approvable even if it has some locations that are closer. And then the wells, tanks, separation equipment, compressors exception, I think that was artfully drafted and doesn't need a more sufficiently protective finding under 4, because those things are located, despite the well pad surface may be closer, at least 2,000 feet away. And the 2,000 is where I believe I at least am with regard to protective from both a public health perspective and from a nuisance perspective. So I think there is a distinction with the difference to B1, 2, and 3 versus B4, which has us having a hearing and making the findings contained within B4. I would welcome other commissioners' comments on this point. Commissioner Messner, and then Commissioner Putnam.
I would agree with that because that's the way that I interpreted it when I read it. So I agree with what you said.
Commissioner Putnam, I think you were next.
Thank you, Mr. Chair. I agree with your assessment. Had one detailed question we can come back to on B3, which is why just those 4 categories and not other things like frac engines or stationary engines or other sort of things that could create some of the same effects as the 4 specifically identified, but can come back to that after your more structural question.
Yeah, let's do that, and let's put a pin in it so we remember to come back to that. We can ask staff how they came up with that list. Other commissioners on this more structural question? All right, I'm going to say, seeing no comments, there's consent, but I hate to do that if that's not the case. So are we comfortable with the staff structure of the 1 or as opposed to 3 ors and an and? Okay, seeing nodding of heads there. Okay, so that gets us through that. I think that where we find next, if we flow through this, is in paragraph 4, we now have rubbed up against the substantially equivalent protections issue. In some regard, I believe there has been some consensus amongst some of the commissioners that this is not to mean that it will always equate to distance being the most protective thing and you can't use the other suite of tools. And I think I spoke to that. I think Commissioner McGowan spoke to that. I think Commissioner Messner spoke to that. The others may have, and I'm not purposely leaving people out. Do folks want to speak further to the issue of substantially equivalent? 1, 2, do folks feel there's a need to further define it or not? Or 3, do folks feel like we've provided sufficient information to our AAGs, and this question goes to the AAGs as well, that they can add additional language into the statement and basis and purpose that is consistent with what you've heard from commissioners? So I'll stop there and see if folks want to unmute. AAG Davenport.
Thank you, Mr. Chair. Yes, I think I've gotten sufficient indications of the Commission's intent to include statements in the statement of basis and purpose. Of course, the Commission will still have an opportunity to review that description in the statement of basis and purpose before a final vote.
Commissioner Messner.
Just a legal question on this, or an interpretation question, I should say, is so I believe in the 100 series we have already a definition of substantially equivalent, although perhaps that's substantially equivalent information I can't remember. And so, you know, would that cause confusion if someone tried to apply that definition to this particular rule?
AAG Minor Davenport.
I can start and then turn it over to Mr. Davenport. I think that's perhaps a challenging question for a lawyer to answer on the fly. I do think that any time a body of case law is developed in one context, it can be challenging to, in really not just a body of case law, but a body of something like Commission Decision 1 context, apply it in other contexts, though I think to the extent we are thinking about something like the Commission making sequential decisions on permits where you all will get familiar with the meaning of this term over time, perhaps that does provide some additional certainty about how other meanings and interpretations of the term would be sort of addressed and considered over time. That may not have been a great answer, so perhaps
I think Commissioner Messner has a follow-up question.
Well, and maybe I'm not clear. I think that we utilize the term substantially equivalent when we're talking about substantially equivalent submittals from local governments or the federal government. We defined that. And I guess I'm concerned that that definition may not apply in this circumstance, even though the term is exactly the same. And so does that cause a problem?
AG Minor.
That is one reason staff did not propose a definition of the term substantially equivalent. It is, as you noted, used in other places in the rules and would potentially require either using different information or a different term in Rule 304E, as you noted, where that is used for submissions for similar plans or information given to federal agencies and local governments in their permitting processes, or crafting a definition that would work in both places. So certainly should the commission choose to go in the direction of adopting a 100 series definition of substantially equivalent information, it would require, as with all 100 series definitions, careful thought about each of the places that the term is used in the rules.
But we do have that in there, right? In the draft rules, a definition for substantially equivalent?
There is not a definition of substantially equivalent.
Oh, there's not. Okay, so I apologize. I thought there was. I misspoke.
In AAG Minor, just because we're using this language here and in the other place, they can have different meanings. I mean, because I think they do have different meanings. I think that substantial equivalent under the 300 series means that we have found that information provided to a local government is satisfactory to meet our criteria for a permit to be issued, essentially. And again, here, I'm interpreting, or my thought about substantial equivalent, and I'd like this to be just into the statement and basis, is that this language recognizes that maintaining a distance of 2,000 feet from these units is just one of several ways to protect public health, safety, welfare, the environment, and wildlife resources. I think that this rule is establishing that there are other ways to achieve substantially equivalent protection through all the things that are down lower in the rule. Those 6 or 7 other things that if you combine them, you end up with substantially equivalent protections. And so that's how I come down to feeling like we've not created something that is not workable. We have created something that is a good off-ramp. And I would be comfortable with the AAGs putting into the statement and basis some of the language that they can call from some of the commissioners today, so that we do have parameters around what we mean by the term substantially equivalent in this particular Rule 604B4. Where are others standing on this issue? Commissioner Gonzalez.
Thank you, Mr. Chair. So I just kind of want to clear that up, right? Because I've had some problems with that language, and I appreciate the clarification that you've offered. And so the way I understand it, and I want to make sure that I'm on the same page, that I'm understanding what you're saying, is that a substantially equivalent protection is just another protection that protects and minimizes adverse impacts to public health, welfare, safety of the environment, wildlife resources.
Yeah, I think it's, again, as I believe I heard from Commissioner McGowan and perhaps Messner and myself, and maybe even Commissioner Nanjapa, I think it is that it's recognizing what is in the siting requirement, that distance is one tool, but it's also recognizing the full suite of tools that exist for operators who feel that they can't meet the distance piece, but that they can meet substantially equivalent minimizing and mitigating adverse impacts by using the other tools, that some of which we've identified in this particular rule, others of which may not be identified, but they could also bring to the 510 hearing. And then by combining those things, we end up with substantially equivalent protections, and we end up with a place where we can say, this is approvable.
Thank you, Mr. Chair, for that clarification. I think we're on the same page. I have a problem with kind of multiple standards in the language throughout the rules, but that's, I seem to be in the minority about that. I think that with appropriate language in the statement of basis and purpose, that we can clear up what we mean with that language and with this rule.
Thank you, Commissioner Gonzalez. Commissioner Nanjapa.
Thank you, Mr. Chair. I did not voice anything on this in particular yet, but
Thank you for that clarification. Sorry.
I will say that it does feel a little bit confusing for me, because when I think of substantially equivalent in the other contexts that we talked about, it's like, the NEPA evaluation and we talked about sort of like cumulative effects being substantially equivalent to our cumulative impacts analysis. And, maybe we might add something else to that. So, in my mind, it's always like substantially equivalent to something. So that's the piece that doesn't, to me, I don't understand how it adds beyond just saying that the conditions of approval will provide protections for public health, safety, welfare, and the environment. Knowing that we are, the reason that we're going to be undertaking this particular hearing pursuant to Rule 510 would be because it's going to be a location that's less than 2,000 feet. And understanding that there are other ways, and I agree that there are, it's not, I don't think it should be substantially equivalent to 2,000 feet, because I think there are all these other measures. I'm just wondering, I guess I'm also agreeing that that specific phrase does get confusing, and we did hear that from all sorts of parties in terms of their interpretation, and I would agree that that's could introduce more confusion than intended.
Other commissioners on this point? All right, so I'm not seeing others with comment. I believe I'm still just one. Commissioner Putnam, did you want to say something before I start rambling?
Thank you, Mr. Chair, and I never want to get in the way of your rambling, but I did want to note just quickly, and I think it's a bigger picture conversation, that we're undertaking a new experiment with a professional commission that provides better ability to provide adaptive management to these rules, and they can be adapted over time. So if we find that this concept isn't working, I think you can change it. I think we should go in with the expectation that none of this is set for all time, and that they should be improved as you learn. And I think you're going to learn a lot. We're going to learn a lot as we move ahead and actually start processing. So I think we should try to the best we can this time around, but also know, we should think about, this is a work in progress and continue to improve it over time.
Wise musings that are much better than my ramblings that you cut off. Thank you, Commissioner Putnam. I think that's a very true statement. And, the other thing that has been going through my mind, and this is the lawyer in me, but as we, if we were to leave this where it's at, and as we turn it on, and as we get applications that attempts to meet the criteria at 4, we're going to create a series of cases. We're going to create approvals because I do believe that we are creating an off-ramp that should be usable as to blunt the otherwise blunt setback tool, or to refine the otherwise blunt setback tool. And as we do that, I think I think operators, I think our stakeholders are going to start to see what are proposals that we have found approvable and what are proposals that we have found not approvable. And I think that will be helpful. And I also come from the perspective of having been director for 18 months, and objective criteria, when it initially started was more difficult for my staff and more difficult for the regulated community. But it did get better as we did that. And again, we're going to be having hearings weekly, I would think. So I appreciate those comments. Other comments from commissioners on this issue? Okay, seeing none, are we in are we in a place where people are comfortable that Joel will, and I'm sorry, AAG Minor and AAG Davenport can assist staff with describing the intent and the statement and basis and purpose for the commission's review prior to the final vote? Commissioner Gonzalez, and then Commissioner.
I look forward to seeing what AAG Minor and AAG Davenport put together.
Commissioner Messner.
Yeah, and I'm just going to throw one other monkey wrench into it, and not for necessarily debate now, but so it's clear that you know how I interpret it, and perhaps could be utilized in the statement of basis and purpose. But AAG Minor, can you go back to the whole screen there, or just to the left a little bit? There you go. Thank you. So the way that I read this, and I'm trying to just utilize other terms so that it's clear what I mean and not just getting hung up on substantially equivalent. And so when I read this, what I'm reading is, the commission finds, after a hearing pursuant to Rule 510, that the proposed oil and gas location and conditions of approval will provide significant additional protections to ensure the avoidance, minimization, or to ensure that the site avoids, minimizes, and mitigates adverse impacts to public health, safety, welfare, the environment, and wildlife resources, including disproportionately impacted communities. And so utilizing other words, that's what I mean.
Commissioner Nanjapa.
Yeah, not to keep kicking this horse, but I think why not equivalent or more, or something to that effect. I think by using that specific phrasing simply because it's used elsewhere, it just potentially creates more problems. But something along those lines of, and I agree with what Commissioner Messner just described as what is intended. I think we all mean the same thing, but it's just the wording that's getting us a little hung up.
Do others care to comment on Commissioner Messner's comment and or proposal? Commissioner Messner, no one seems to want to comment on your proposal.
It wasn't really a proposal. I wasn't suggesting changing the language necessarily. I was just suggesting that's what I mean, and that that language could be utilized in the statement of basis and purpose to better clarify what's in here.
Just like when I provided some language from my perspective. So I think it's awesome that we've got two really smart attorneys with us and assisting us with this. And I too would echo Commissioner Gonzalez's comment that with that, I look forward to seeing the language in the statement and basis and purpose. And we would be looking at that before the quote final vote. And we should probably talk about the final vote here before we adjourn for this afternoon. So it is now AAG Minor, would you mind going back to your other slide and just let me see if what other things we need to be looking at. So I think we've gotten through the first sub-bullet meaning of informed consent, substantial equivalent, inclusion of tenants. Commissioner Gonzalez, header, title of rule. I think that was yours.
Yeah, thank you, Mr. Chair. Yeah, that was mine. And again, it's just to really try and frame our intent of what we're trying to talk about with these off ramps, with a soft setback. I think it's important that the title capture what's actually in the rule, because the rules, you know, it's setbacks plus, it's setbacks and siting requirements. And I think that siting requirements piece is really important to acknowledge. And I would propose that we call 604 setbacks and siting requirements.
AAG Minor, can I put you on the spot, or AAG Davenport, whomever wants to take this curveball question? But it segues off of Commissioner Gonzalez's statement about the title. And I don't know the answer to this, and I apologize if this is coming out of left field, but what's the difference between the title and the substance in a rule?
Mr. Chair, I'm happy to give my perspective on that, and Mr. Davenport may have a different one or a similar one.
I also, just before you go there, Commissioner Gonzalez, you may know the answer to that question too, and I don't mean to disregard because it's your point, I guess, but in order to evaluate the idea, I wanted to know the differences there, if you understand. So AAG Minor, you're first.
So you may actually recall a discussion about this that I think came up during the 300 series with respect to one of the titles of a section of Senate Bill 181. But courts do use the title of a statute or the title of a regulation as one interpretive aid if there is perhaps ambiguity that needs to be interpreted in the context of a regulation or of a statute. With that in mind, it is not binding, right? It's not the binding regulatory text. And I think that throughout the Commission's rules, staff have viewed the title of the rule as more a measure for transparency with the public and everyone reading the rule to get guidance about what the rule is talking about. So while there is some legal use, should there ever be a lawsuit and the need for a court to interpret ambiguous language, they could look to the title and use the title as an interpretive aid. But I think the primary purpose of the titles of rules is really that transparency and making sure that everyone knows what the rule is about.
AAG Davenport, are you gonna me too here, or did you have others to add?
I had a me too.
Yeah, I'm gonna let you go first the next 3 times so that AAG Minor can do me too, but I really appreciate the consistency of our legal advice. Others with thoughts about Commissioner Gonzalez's suggestion here? Commissioner Messner.
I've got a clarification, and then I'll have thoughts on it after that. But so you're suggesting after the number 604 setbacks that it have / citing requirements, is that correct?
Commissioner Gonzalez.
Got to find my mute button. Not exactly. My suggestion is that we call it setbacks and citing requirements.
Setbacks and citing requirements. And so that would assume then that in the body of the language that's underneath that, and I'm gonna pull it up on my own screen here. At some point in, A or B and any of the subsets underneath that somewhere there would also be utilized the term citing requirements. Well, there already is in B.
It's right there in B.
Yeah, it already is in B.
And that's kind of, that's half the rule.
Correct. Okay. I don't have a problem with that because, like you said, it is in B, and it is setbacks and citing requirements, and I don't have a problem.
Other commissioners with thoughts about this idea? Commissioner Nanjapa.
Well, I think it's a good suggestion. I think it adds additional clarity. Thank you.
Okay, I'm good with it as well. Commissioner Messner.
I'm just going to make a point here that, no, I'm not going to make a point. Thank you.
The non-rambling ramble. Okay, I think we are good with that. Let's go back to our other document. "500 feet in Rule 60A4, I think we took care of that. And this required criterion, that was my 3 ors and an and that I think we've gotten through. And then clarity about the role of commission hearing in 604 and interplay with 500 series. I think we've covered that. Does anybody feel we need to jump further into the last bullet? Going once. All right, what I would like to do right now is take.
Actually, Mr. Chair.
Oh, Commissioner Putnam, go ahead.
I did want to go back to the one issue that I pinned related to B3 and the question about the 4 specifically identified areas, and then had one other suggestion for statement of basis and purpose, not necessarily the actual rule text.
Please.
So on the, and this is not related specifically to B3, but I think just generally related to the question of the presumptive 2,000 feet, that I think it's useful to include some language in the statement of basis and purpose, kind of picking up on some of the dialogue that we've had, including this morning, about the desire to continue studying these issues to better refine the science so that we can, look at this in the future. This is based on the best evidence we have today, based on the substantial evidence in this hearing, but all those things are evolving. The state's investing in that evolution. Industries mentioned that they've done that. A number of the educational and research institutions in Colorado are doing it. And I think, again, it's helpful to create an expectation of adaptive management based on improved information over time, a reasonable cycle of review, all of those sorts of things.
I couldn't agree with you more. I think that's exactly right. And one of the things that I was going to say when we got to the point of we're getting close to being done with 604 was just that, is that with this commission as a new entity, with the folks in your shop, Commissioner Putnam, with your CDPHE hat on, I think that I want to make sure that we re-up the work that we started to do around getting new science around oil and gas locations during pre-production in particular, so that in a year or so from now, we can revisit and we can look at new science that is not industry science or that is not environmental science or whatever other kind of science, but it's our science. It's our scientific studies that can help inform what should be a, I don't want to call it evergreen, I hate that term, but make sure that our rules and regulations and where we've landed today remain appropriate for oil and gas development, as well as protection of public health, safety, welfare, the environment, and wildlife resources, as we've developed up this additional science. So I wholeheartedly support that notion. Commissioner Putnam, did you want to revisit with staff how we got to the wells tank separation compressors at this time, or do you want to leave it there?
I did. While the rule is open, I think it's useful just to address that question. And just to be specific, I know we had some suggestion from parties to broaden that up in some of the written statements. And it strikes me that if many of the effects that we've been concerned about, effects that we've seen in some of the studies, are based on other sources of emissions or noise or light, that it's not clear to me why we're capturing only these 4 categories. And the places where I think we're missing are stationary and non-road engines. especially involved with the frac or with generator sets that may be powering equipment during pre-production facilities. So I'll just leave that as a kind of basic question and suggestion to at least think about that as a commission.
I was going to call on Director Murphy, but Commissioner Messner raised his hand first. Now he's waving me off. So Director Murphy or some of your staff, do you want to comment on the list that is contained within subparagraph 3?
I'm happy to, Chair. And I have a little childcare incident like many of us are having right now. So if you hear my child or my dogs, bear with me. He's watching trash trucks as is per usual. So the Commissioner Putnam, your question is important. And as staff was preparing this draft, we were trying to focus on the pieces of equipment that are permanent through which hydrocarbons flow and also are the sources of nuisance in our experience. And so that's what led us to select these 4, you know, and also recognizing some of the comments about, as drafted, given the working pad surface, this ends up being a much bigger impact than just 2,000 feet and trying to navigate between those 2 kind of positions. I think we wanted to capture some of the most important sources and most important pieces of equipment, but are open to the direction from the commission on this point in particular, as with any others. But again, we did focus on the ones through which hydrocarbons are flowing and that are permanent.
Commissioner Putnam?
Thank you, Director Murphy. That's really helpful. You know, I think from our experience with the Oil and Gas Health Information Response Program, you know, we also get from equipment like operating diesel equipment and sources of combustion. And so, you know, I think that those matter. And certainly when we're looking at some of the places that we don't have as much science, you know, they are related to some of the diesel particulate and other issues. That was kind of one of the holes identified in our study that we just didn't have resources to study. So, you know, I would start with a place of protection on that front and include, you know, areas where if you've got a whole bunch of gen sets running continuously during months at a time during a pre-production phase or a frac, you know, I think those are also places worthy of protection, especially since a lot of our concern that we saw in the health study was pre-production. A lot of the complaints that we get is pre-production as much as the kind of permanent equipment and final configuration.
I think I appreciate those comments, Commissioner Putnam. I think I'm somewhat of this perspective to take staff up on the defined equipment that they have defined. I know there was a lot of discussion about this, and again, I would sort of take this up as let's, at least my vote would be, let's leave it as is, but let's reflect on how and whether it's working as we turn on 181 regulations for the year of 2021 and see whether this off-ramp is working or whether it's not working, and be ready to be reactive if it needs to have additional components, or alternatively, is no one taking us up on it? And I don't know the answer to that. We did not get a lot of comment about that from our industry stakeholders. Commissioner Messner.
Thank you, Mr. Chair. So this ties into another question that I have regarding measurements. And so I just first want to ask that question because I just need to be reminded. The decision to measure from to the edge of the well pad was in order to be able to capture all the different potential sources of adverse impacts within the distance. I think so. I'm asking that question. And then remind me why it was not contemplated to measure to the nearest source of potential adverse impacts or something like that. I can't remember the discussion, so.
Chair, may I? I don't know if the chair knows he's muted. Okay.
I did not know I was muted. Director Murphy.
Thanks for the question,
Getting
Commissioner
late.
Messner. It's very late, and this is a heady topic. Thank you for the question, Commissioner Messner. Staff has elected to recommend measuring from the working pad surface for a number of reasons. One, it's much more clear to administer. It provides flexibility to operators as equipment may move on site to accommodate different features, to accommodate different configurations or drill rigs or what, kind of a number of different issues that could otherwise change throughout the process. It creates more consistency for people who are monitoring and looking at proximity and trying to evaluate what a proposal is and how it's measured. Historically, staff has gotten a lot of questions from the community about to the effect that, when I use a rangefinder to measure how far this pad is from my house, it shows up at 1,200 feet, and but it says that this is this is not within the 1,500-foot buffer. And so those are the challenges. I think we create much more transparency and consistency by measuring from the well pad surface. I also recognize the concerns that have been raised about the extension of distance because we're measuring from working pad surface instead of equipment. And so that's why staff tried to identify a precise list of equipment to provide this exception from the 2,000 feet. And it's trying to navigate between a couple of different points. And, staff is also, I think the thing that's important from staff's perspective is that working pad surface applies to so many other rules than just 604. And so we wanted consistency in this, and that's why we've advocated for it. At the same time, these are your rules and you will do what you tell us to do. But working pad surface and the measurements apply to any of the other 2,000-foot measurements throughout the rules for noise. And I think now I'm just becoming redundant, so I would happily take further questions. Walter would like to say more.
Thanks for that. I appreciate the reminder and the point that it is utilized in a number of other rules and to create consistency. I do think that's really important. I think the only concern that I have is utilizing these limited pieces and taking the measurement from those pieces. I think as I read this, it's taking the measurement from the pieces, whatever that equipment is, and then to the receptor, and that anyone can propose that, and as long as they meet the standard, it's met, and so does that not negate the overall intent? And I'm not trying to be problematic here, but I do think that, I understand the intent here, but I guess my question is if this makes more sense in this particular situation and we want to use it as an off-ramp, do we actually want to change how we're measuring this stuff to just be to measure to the point of the point of potential adverse impact? So whether that's a tank, whether that's a fracking rig, whether that's a wellhead, does that accomplish what this does as an off-ramp versus just utilizing this as a potential off-ramp that most applications will be able to utilize? So just a thought there.
Commissioner Messner, just from a practical perspective, you are still kind of coming in and out. So the next time you talk, eat that microphone. Thanks. Other commissioners that would like to respond, or Director Murphy, if you would like to further respond to Commissioner Messner.
Chair, I'm happy to take that on a little bit and articulate why I at least think that this is the appropriate structure. And I don't get to vote, so on some level it doesn't matter as much to hear from me. But the reason that we've crafted it in this way Commissioner Mesner, is that there are different considerations at different phases of development. And so when I'm thinking about the construction stage, I think we do need to be cognizant of impacts within 2,000 feet, given what I've heard from the commission on this issue. And if we're measuring from equipment, it's harder to do that. And so that to me is the reason why I think it is appropriate to measure from the working pad surface when we're thinking about a number of other rule provisions, in particular noise, et cetera, to acknowledge that that is the framework through which we want to look at these locations, and also acknowledge that a subset may be accepted from a commission finding under 604B4, but are also otherwise coming forward to the commission for consideration under the OGDP and for compliance with other regulatory requirements that apply to that pad, that because it is within 2,000 feet. So I think it creates some consistency that's important from staff's perspective, but I look forward to the direction from the 5/7 of you.
Other commissioners desiring to comment on this issue? All right, I'm not seeing other commissioners desiring to comment, which I think means that your proposal, Commissioner Messner, is maybe going to remain that. And perhaps we've got consensus around that the B3 is staff's clever approach to establishing an off-ramp where the potential emitters are more than 2,000, then the working pad surface can be closer, which I think, again, sort of allows for creative approach by operators in how they are constructing their facilities, and perhaps will serve as an off-ramp that maintains that protective from public health and protective from welfare of the 2,000. AG Minor, and not to be presumptuous, but can you go back to your other slide and see if we have ticked off the list with regard to setback?
And Mr. Chair, while we're looking at that list, I think before I had sort of toggled over to the other document, you all discussed the meaning of informed consent, and it sounded like you wanted staff to address that in the SBP. And I did just want to get that clarified, that even though there isn't perhaps a comment in the other document, that is indeed your intent.
I believe so. I think we've heard from you and AAG Davenport that there is case law that will help define this. I think we heard from some of the stakeholders with proposals, and I will leave it to you and AAG Davenport's best legal minds to come to a workable, practicable other definition around that in the statement of basis and purpose. Commissioners, we got through the first of the contentious issues, I believe. We still have several more to go, and then we need to wade through each of the series with the more precise picks on things that may exist. It is now 5:15. We generally, I think, want to try to maintain familyness and other facts of life. And so I would suggest that perhaps we could be done today, having done some really great work here. AAG Davin, so first off, let me see if there is there consensus that we should be done today and come back at 9 in the morning. Yep, okay. AAG Davenport, let me turn to you. We've not done this before, but and can you sort of inform us, remind us of the fact that we've got the 2 through 6, and we're going to be making decisions on the 2 through 6 from a substance perspective. And then we're going to close the record, but we're likely not going to be done with this rulemaking because we've got to conform 8, 9, and 12 into 2 through 6. So if you could sort of outline your best case scenario of how that would work. I think we've done some good work here. If there's such a thing as like a straw poll that we could say that we're comfortable with Rule 604 so that we can say substantively we're done and then we can tackle the others tomorrow. And I'm sort of thinking straw polls after each one of the sticky issues. But please, if you could help me with that.
Sure, happy to, Mr. Chair. Commissioners, one option that the chair already mentioned is to take a straw poll at the end of big issues or rule series, which is really just a check-in to make sure that you commissioners are comfortable with where you are on that particular rule or rule series, to the point, I think, where if we got to when we get to a final vote on that rule, you would vote to approve it. That's the purpose of a straw poll, recognizing that it's not binding on you, but it's a good check-in to make sure that you're comfortable with where the rule language landed.
I appreciate that explanation, and just as one commissioner, I tend to like that. I don't like the concept of doing all this work and then just leaving it open for potential further efforts on the part of folks to try to further, provide us with information. So I would appreciate a straw poll vote on the Rule 604 as we have deliberated it this afternoon. And I would appreciate doing that on the other 4 or 5 sticky items and then on each of the rule series. And then we would close record and then move to 8, 9, and 12, knowing that we've continued this rulemaking already to something like October 30th and 31st, I can't remember. And that's the time that we would come back and do the collaboration coordination between 8, 9, and 12 and then these rules. Commissioners, do you have thoughts about process? Commissioner Gonzalez.
Thank you. No, I think that's a good process to follow, and I support that. I will tell you that I'm pretty good with where we landed today, and I look forward to seeing the homework from the AAGs come back. But I think I'm ready to move on to the next rule series.
Other commissioners comfortable with this process? Commissioner Messner.
Thank you, Mr. Chair. I'm comfortable as well, and I think that it's important to. I guess my hope is that people actually look at this and people who are actually listening and absorbing what we're actually talking about here. That some of the rhetoric goes out the window, and we can continue to move forward and figure out how the best way to implement 604 as we move forward. I think that some of the feedback I've gotten from operators is the need to, have some certainty, and particularly from an investment scenario. And I think probably one of the best tools to have clarity and certainty and not scare investors away is not to propagate information about what this isn't. And so this is not Proposition 112. This is a well thought out surgical set of rules to look at implementing setbacks and siting guidelines. Is that correct, Commissioner Gonzalez? Is that what we had?
Siting requirements.
Siting requirements. And so, yeah, I'm good where we're at. So thank you.
Other commissioners? Well, I too am good where we are. I think that this is, I find it interesting that Rule 604 is the place where we have found that by listening actively to Coloradans and our stakeholders, I think we have found a workable rule that is protective, that also allows for off-ramps that I envision will be used to allow for permits to issue, and that allows for off-ramps where there are proposals that don't meet the off-ramp, then they don't issue. And so I'm very proud of the work that we've done on this rule. So my straw vote on this is also a thumbs up. Commissioner Najapa, does your daughter want to vote?
She would like to move to adjourn. But no.
Are you conceptually in a thumbs up place as well as we take this straw poll, and or Commissioner McGowan? Commissioner Putnam would also love to hear from you, and or Commissioner Bogue, who I think may be on the phone, and instead of Commissioner Gibbs.
I'll say, Mr. Chair, just for the record, I still remain a little bit uncomfortable with the 500 being the sort of bottom boundary of our setbacks. Knowing that there is this opportunity for, for folks to consent if they're going to go, further within that, it makes me a little bit uncomfortable, but I respect the views of the other commissioners, and given that no one else raised that as a concern, I'm comfortable moving forward.
Commissioner Putnam?
Thank you, Mr. Chair. I think there's been a lot of really thoughtful work that went in to find a reasonable balance here, and I think it's a good way forward and support it.
Agreed. Agreed as well. Thanks.
Thank you. Commissioner McGowan.
Thank you, Mr. Chair. I think I've said to some folks who I've talked to in the past week that it's probably not going to be perfect the first time out, but let's drive the car, kick the tires, give it a test drive, and see how it works. And if we find that there are flaws, take it back and fix it and update it so that we are able to have thoughtful discussions and make good decisions. I think this is a good starting point.
Great. Great work, team. Thank you to our stakeholders, 137 of which are still with us. We will, at this point, then adjourn to 11 p.m. tomorrow, or 11 a.m. tomorrow, excuse me. We had some folks that couldn't make it for the first part of the day, and we had noticed it at 11. So let's be consistent. If I could have a motion to adjourn until 11 a.m. Tomorrow, September 25th.
So moved.
Second.
All those in favor signify by saying aye.
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 See you at 11. Thank you, Colorado. Thanks, everybody.